Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the fair use doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
The list of 10. And so that's where we're at. I'm prepared to go one by one through the remaining 8. Sound good, Mr. DeMore?
Yeah, I think Mr. Vander and I will, depending on which one we're on, we may switch if there's additional argument needed.
Okay, great. And then, so I have the that 3 filed May 28th, and then I have defense response. I don't have a file date on that, but I think it came in yesterday, if I remember correctly. Yes. All right. So let's go ahead and get started on this issue of what does a rebuttal case look like. In People v. Carter, a murder case, the prosecution theory was that the defendant killed the victim with a wrench and had left the wrench, the victim's wallet, and his own red cap in a certain slough. The defendant denied that he had been to the slough and had left anything there. The prosecution in rebuttal introduced the red cape, giving no reason for failure to offer it in the case in chief. In reversing the judgment on other grounds, the court expressed disapproval of this tactic and gave the following explanation of the rule. Quote, in a sense, all evidence that tends to establish the defendant's guilt over his protestations of innocence rebuts the defendant's case, but it is not all rebuttal evidence. The purpose of the restriction is to assure an orderly presentation of evidence so that the trier of fact will not be confused, to prevent a party from unduly magnifying certain evidence by dramatically introducing it late in the trial, and to avoid any unfair surprise that may result when a party who thinks he has met his opponent's case is suddenly confronted at the end of trial with an additional piece of crucial evidence. Thus, proper rebuttal evidence does not include a material part of the case in the prosecution's possession that tends to establish the defendant's commission of the crime. It is restricted to evidence made necessary by the defendant's case in the sense that he has introduced new evidence or made assertions that were not implicit in his denial of guilt. A defendant's reiterated denial of guilt and the principal facts that purportedly establish it does not justify the prosecution's introduction of new evidence to establish that which the defendant would clearly have denied from the start. This cites not only People v. Carter, but People v. Daniels and People v. Nunez-Citelli. It is improper for a prosecution to withhold crucial evidence properly belonging in the case in chief and to present it in rebuttal to take unfair advantage of the defendant. So that's the general rule of law that we're working under. In this particular case, not only has the defendant entered not guilty and not guilty by reason of insanity pleas, the defendant sat for 3 extensively long interviews with doctors and gave statements about the nature of the crimes and, of course, about his mental health condition. So this is an unusual case in the sense that the prosecution had more information than they would have about a defendant who then ultimately did testify. And so we have that additional background here. So now turning to the specific requests made by the prosecution. The first is the people seek to introduce a record of additional such communications during the time period of April 2023. And I don't have any indication about what they are. It wasn't listed, so I don't know what piece of evidence we're talking about. So that request is denied. So, well, it should have been in your brief. So what I'll allow you to make your case, but I mean, I have no idea what you're referring to here. And we did have communications, and of course, there was an opportunity to present all of this in your case in chief. But particularly, what were you talking about then?
And this has become a point where it's not actually rebuttal evidence. This was a document that was presented to the defendant during his cross-examination. This was the subpoenaed records that were showed to him. And so it's...
Which exhibit is that?
I'd have to get the list.
Okay. Was there any objection to that?
No.
Right. So number one then is withdrawn in effect. We'll rule on the exhibit. Number two, the defense has introduced evidence that the defendant's roommate decided to make a tip to the police about Dominguez. So this request for rebuttal evidence is denied. All of these witnesses were on the witness list by the prosecution, could have been called in the case in chief. And anyway, that's where we're at. And there's nothing specifically really here as to what they would be testifying to and how it's responding to new evidence. Number three, the defense has introduced evidence of defendant's conduct and interaction with roommate. People seek to respond with observations of two of the roommates. I guess that's what I was speaking to just a moment ago. So that one's denied for the reasons I just said. Those people were on the list. Back to number two, since I mixed that up. The people will seek to introduce evidence of why the roommates did that, to make a tip. So they're 2 and 3 are related, and they're both denied. Number four, the catalogs. Mr. Hutchinson, your response on the catalog. You want to articulate that again?
So the people did introduce evidence of catalogs. Catalogs have been admitted into trial. They did not introduce evidence about how long these catalog records are maintained. I only introduced evidence regarding body cameras, which are completely separate recording. And after questioning Officer Story and Detective Yu about who knows how long they're retained, I was finally directed to Ms. Lyon, who was kind enough to come in without a subpoena and testify. Body cameras of arrests are retained for 2 years. Citations, contacts are retained for 1 year, and then they are deleted. The people now want to bring in evidence of how long catalogs are retained. That is not rebuttal evidence. That is an entirely different document. I never introduced any evidence of catalogs.
Let me ask you this. When was this evidence produced to the prosecution that the defendant had interaction with a police officer a month or so before the stabbings, in which he had given the name John Joe Haas? When was that evidence discovered to the prosecution?
Yes, that was mentioned in the reports of Dr. Weiner and Dr. Ree. In the court notes, beginning in January, the people started subbing every law enforcement agency imaginable seeking records relating to John Joas. And they actually have all those subpoenaed records that they could not find in John Joas. Those are marked as exhibits. They just simply have not identified them. So they've known this since the experts' reports were disclosed in early January, and they began subbing records in January.
Were the police, what was the name of the key witness that was called regarding the video retention policy? What was her name?
Jean Lyon.
Lyon. And then was she asked on by the prosecution about the catalogs, and did I prevent them from getting that information at that time? Is that how that played out?
Yes.
Right?
There may have been some question about catalogs. I believe I objected outside scope.
Okay. I'm going to allow number four. I think that it is responsive and it would clarify things. It would be instructive to the jury. I think in retrospect I should have allowed the questioning at that time while the witness was on the stand. And so I don't see prejudice to the defense to allow that. Number 5 was withdrawn by the prosecution. That takes me to number 6. The defense has introduced evidence of defendant's demeanor, and the people will seek to introduce a video that further demonstrates the defendant's demeanor and conduct in court. Is that the video from the competency, one of the competency hearings? Is that what we're talking about, Mr. DeMora?
It is, Your Honor.
Okay. All right. That request is denied. That video has been out there. It was a big deal when it happened. It's a key piece of evidence in this case. Obviously, it goes directly to the truth of the matter, where the defendant spoke in open court, admitting the offenses. His demeanor in court is also evidence of his mental health condition. So there's a variety of reasons why that video might be relevant. The court had clearly indicated to the parties that it was off limits, so a request should have been directly made to the court to admit that prior to the start of this trial. It was off limits because at the time the defendant had exercised the Fifth Amendment right to remain silent. It was further off limits because the defendant, at that point, the court had declared a doubt. So there were a lot of problems with that statement and that video of the statement. And it's an issue that really should have been vetted prior to trial. It was an issue that goes directly to the guilt of the defendant and to his state of mind, and it was available for the last 2 years and should have been presented in the case in chief. It is not rebuttal evidence whatsoever. I will further note that the prosecution chose not to mention state of mind evidence in their opening statements, and they chose not to produce an expert on the issue of the defendant's mental health condition. And really, other than the horrible and unthinkable nature of these crimes, the actual commission of the crimes and the way they were committed, there really is no evidence in the people's case in chief regarding state of mind. And so they're drawing inferences for the most part from a few circumstances in the defendant's life at the time regarding school relationships, and then they're drawing inferences obviously from the nature of the crime. So this, to the extent that people want to show that, should have been done in the case in chief. So now we move on to number 7. The defense has introduced evidence of defendant's prior examination of mental health professionals. They want to seek to introduce writings by the defendant which show defendant prior training and knowledge about psychological evaluations. This is something that should have been produced in the case in chief as well. And also, there's really no, the prosecution doesn't have an expert to explain how this might impact psychological testings. The one expert that testified to it clearly stated that it wouldn't have any impact. A class on introductory to psychology and undergraduate. Number 8, we move on to is defense has introduced video evidence of the defendant's interrogation by the police, and they want to mention now they want to introduce an interview video recorded or audio recorded, one of the two, from the jail. This is evidence that the people have had and could have introduced in their case in chief, so that request is denied. And then we get to number 9, that's been withdrawn. So I move on finally to the last item, and it's number 10, and that is the defendant indicates, the defense indicates the defendant will testify. People will seek to introduce prior inconsistent statements. That would be fair game for rebuttal, certainly, but I don't have any statements listed here, and I don't know what the people are asking for. Mr. DeMora, do you have anything specific?
I'll defer to Mr. Vanderhook on number 10, and he can look forward to more on that.
And
All right.
with regards to that, we were looking forward towards Dr. Weiner and Dr. Ree. Dr. Weiner, I believe, is going to be here this morning. Dr. Ree has indicated that she can't come in until tomorrow afternoon. specifically for Dr. Weiner, these are statements by the defendant related to each of the stabbings and the defendant's memory as to what occurred during that time.
So what I really would need at this point to rule on a motion is what did he testify to and what did he tell the doctor? Almost like a chart. That's what I need to rule on. The vague notion that he said something different doesn't get me there. I can't rule on that.
Yes, Your Honor. So the testimony from the defendant was that he was on a bench. He indicated the bench that prior testimony established was about 50 feet away from Mr. Breaux's bench, and that he then saw something over at Mr. Breaux's bench and lunged/ran to Mr. Breaux and then blanked out. His prior statement to Dr. Weiner is that it's twofold. First, there was testimony from the defendant that this was the first time that he heard clear voices and was able to understand what the voices say, and there was a prior statement to Dr. Weiner that he did hear words before, such as hurry up and other phrases. And in regards to the actual occurrence of the crime, the defendant, I just went over what the defendant testified to, and the statement in Dr. Weiner's report was, I started looking around and got paranoid, and got more paranoid when I saw a shadow figure sitting next to me on the bench. He added, and that Mr. Dominguez thought it was a supernatural being next to me. Yeah.
This is the next to me, that's the point here?
Yes.
Okay. I think the defendant explained that as testimony, but Mr. Hutchinson, is that impeachment?
I don't believe so. What is important, the court may recall the cover letter that Mr. Van Hook sent to the experts. He raised this point with Dr. Weiner. Dr. Weiner went out and spoke to Mr. Reales Dominguez about this issue, and Dr. Weiner said it did not impact his opinion in any way. We're basically arguing on what next to me means.
Right, I didn't find the distinction very compelling. I'm dealing with a person who has a severe mental illness. He's recounting what he remembers to a doctor. He's recounting it under fairly aggressive cross-examination, quite frankly, but also direct. And it's the same account, as best I could tell. And I've read Dr. Weiner's report and heard his testimony. The word next, it's really parsing and trying to pin the precision in language in a situation that is much more complicated than that. But what else from Dr. Weiner?
So regarding Sycamore Park, the defendant testified that he saw a shadow figure, described a void in the mouth and things of that nature. During his prior statement to Dr. Weiner, there was no mention of any shadow or seeing a shadow or seeing a void or anything like that. He stated that he saw some dude come down the bike path, indicating a human rather than seeing a shadow. And then his statement to Dr. Weiner is that only after he stepped into the path, or the first mention of believing that there's a supernatural entity or anything wrong in Dr. Weiner's statement comes from after the collision. He says that I saw some...
All right, I'm going to stop you there. Mr. Hutchinson, thinking deeply about this, I really don't have a problem with the prosecution recalling Dr. Weiner to go over the statements that the defendant made. We didn't allow the prosecution to do that when they had an opportunity to cross-examine the doctors. And so it would seem to me entirely fair to allow the prosecution to probe what these experts heard from the defendant and the impact it would have on their opinion. We know it's not going to change it. I think that doctors have already said that, but I do think it's fair, and I do think it's reasonable that both sides have an opportunity to go over this, because we did not allow it on the defense case, director or cross. What's your response to that view?
Well, I think the only thing I take issue with is that we did not allow it. I could not elicit it because it would be hearsay until my client testified. They had every right.
I wasn't gonna. I see, in my mind, I think I would have preferred your client testifying first, and you made a tactical decision. I mean, you know, I'm not criticizing you. I think it worked fine, right? But it was hard because the doctors didn't go into it. I don't know that I would have really caught me off guard if they had gone into the statements regarding the crime when you didn't do it on direct. That would have really caught me off guard, and I'm not sure I would have allowed it then. So I'm going to allow it now. Okay?
My position is they did have an opportunity. I think legally they did have the right to do that. They chose not to. I think rebuttal should be limited to the specific statements that they confronted Mr. Reales.
I agree with that. Right. I'm going to allow him to do that, and that's what he's talking about.
But to the extent there's other statements they want to go into, I think that is not proper
Right.
rebuttal.
Right. So, and I assume all the impeachment statements, and you don't have to list them now, even though I had asked for that a second ago. I'm going to believe you have a good faith list. All of that relates to the crime, right?
I want to ask Dr. Weiner about what he said about crime 1, about crime 2, crime 3. That's what I want to ask Dr. Weiner.
And your structure is, these are things the defendant was asked during his trial testimony, and now you're either impeaching or I'm actually allowing clarifying. So does that make sense to you?
Yes, I don't have notes with me about what specific parts of the statements I asked the defendant about. And so I may...
Well, we'll see. We're just I'm gonna allow, because I think due process, that's fair. Okay? So then, just to summarize, then I need, it was number 4 on catalogs, and then number 10 on the 2 doctors. Okay?
Can I ask a clarifying question?
Yes, sir.
Apparently they did not subpoena Dr. Reed, and if she's not available until tomorrow afternoon, is the court going to allow, because this rebuttal will probably take no more than an hour.
Right.
Well, apparently they did indicate that they subbed her, so she should be here.
Right.
I'm concerned about how tomorrow afternoon is going to impact the trial schedule.
Right. Right. Okay, well, what's the update on Dr. Reed's subpoena?
So, we got an email yesterday from her that says she received the subpoena, she's not available today, and then she's available tomorrow.
If it was a subpoena sent via email, that's not legal service unless she responded with her California driver's license number. So I'm not sure if she's even under legal
Okay, why don't you meet and confer regarding that issue? Somebody call her, and would you agree to have her on the screen?
Yes.
Right, okay,
We can call her.
okay. Why don't you work on that issue before I make any ruling on that? But I do share defense's concern, and I think prosecution's concerned too about letting too much time slip. Okay. All right, with that then, we have, I've addressed the juror issue, and I've addressed rebuttal case, and we have an outline for that. And then we have the jury instructions, which I now can just set aside for the moment, so we can get through. Dr. Weiner's here, that we do have some area to cover with them. And I don't know if you have a witness on this catalog, but obviously that's a 2-minute witness, very short. Okay.
And Your Honor, if I may.
Yeah.
Before the court moves on, the court ruled on point number 8, which is in the people's motion. The people had a separate motion attached to that Perkins operation. I understand the court's ruling in the people's motion for rebuttal evidence, and that would obviously impact that ruling, but there wasn't a ruling on the specific motion itself.
Yeah. Well, the motion, hold on on just a second. I have notes on that.
Right, I think it's a moot point, given the court's ruling that.
Right, exactly.
The outstanding motion pending for the court.
Well, it's just a motion to issue a protective order if the interview was used, right?
Correct, in the way in which if the court had permitted introduction of that piece of evidence, how it would be introduced in court through a series of different options.
Yeah. Okay, we'll label that the People's Perkins motion, and it's denied as moot, given the court's ruling on the rebuttal case. Okay, super, thanks for clarifying that. We do have work to do on the jury instructions, but let's address the first juror issue. Deputy, like to have juror number one come in. I'm wondering if this needs to be in public. I need to have a record of it. But I just sensitive to all the hard work that our jurors have put in, and I'm willing to do this in chambers with juror number one if I had stipulation to that effect. What's your view, Mr. Kumar?
I think chambers would be appropriate. Would that be with or without the court?
No, well, it's all going to be on the record.
Sure,
Yeah, all on the record. Yeah.
Perfect.
Mr. Hutchinson, I'm just thinking out loud.
Yes, I would agree to, and in chambers, I will waive my client's appearance.
Yeah, okay, thanks. All right, so let's actually give the jury an update that we're going to start probably, this is probably going to take another 20 minutes, except I am going to need to talk to juror number one and juror number two, okay? And I think that by the time I sort through this issue and then we get ready, I think that's a 20-minute exercise. So I'd like the rest of the jury ready at 10 o'clock. Yeah. All right, thanks. Off the record. Thank you, counsel.
Thank you.
Okay, so court reporter with me, and then counsel, you. in time where I have to roll a dice and I have 5 alternates, one of which in a moment will be sworn in and serve as juror number 1. So that's where we're at. That's the first order of business. After saying good morning to all of you and thank you and I appreciate your patience. I had some work I had to do and we were working on the case, but that ran a few minutes. And so we're now ready to keep moving. And so that's where we're at. Okay, so here it is. It's a wooden dice. It has 1 through 6. And whatever number comes up, if it's 2, then I got to keep rolling because I've already moved 2 in. So here's the roll of the dice. Did play a lot of backgammon with my wife over the weekend, so you see. 5. So, yes, there we go. Juror number 5, you can put your badge down at this time, sir, and then proceed, grab your notes, and move to seat number 1. Do we have a bench there? Okay, we'll wait to swear him in until he gets to seat number 1. Okay, could I have you, Mr. Allen, stand up for a minute? And then Mr. Clerk.
Please raise your right hand. You understand and agree that you will well and truly try the cause now bring before this court and achieve verdict ready according to all the evidence presented to you and to the instructions of the court. If you agree, please answer yes.
Yes.
Thank you. Please be seated.
Okay, thank you. Again, thank you for your patience with me. All right, so listen, the people had a case in chief, presented evidence. The defense had a case and presented evidence, okay, and the people are allowed rebuttal case under specific rules, and they do have some evidence they would like to produce. And so at this time then, Mr. Vanderhook, do you have a witness you'd like to call?
We'll call Dr. Weiner.
Okay, and we did confirm he was here, so let's get Dr. Weiner. Okay, good morning, Dr. Weiner.
Good morning.
Thanks for your patience with me. Come on in and stand here at the podium. I appreciate you coming back to court.
Of course.
And I'm going to have the clerk administer the oath. We're going to do just what we did the last time, okay?
Sounds good.
You do solemnly swear that this about to give the cause now bring before the court shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you. Please be seated. Take your first and last name for the record and spell them both.
Stephen Weiner, MD, Stephen, last name Weiner, Weiner, MD.
Okay, great. All right, Mr. Vanderhook, your witness.
Thank you, Your Honor. Good morning, sir.
Good morning.
And when you testified earlier, you talked about doing interviews with Mr. Dominguez, correct?
Yes,
And did you ask him specifically about the circumstances of the stabbing in Central Park?
I did.
What did he recount to you about how that happened?
Objection, narrative, non-prior inconsistent statement.
Okay, listen, I'm going to allow it. I'm going to allow a probing of the statements made by the defendant to the doctor. So go ahead.
Okay, so regarding the murder of David Breaux, so Mr. Dominguez had told me that he was out for a bike ride during the evening and sort of going into the later evening, early nighttime to get some fresh air. He ended up at Central Park. He told me that he then sat on a bench in Central Park. He then noted a figure of some sort. At one point he referred to that as a shadow figure that was adjacent to him sitting on the bench. And at that point, he began to grow paranoid. He also told me that for the first time, sort of in his history of various symptoms, he heard clear voices. Up until that point, he told me that he had only heard like whispers and something described as like when you hear the TV on in the background and you can't quite make out distinct voices, but you know there's something that sort of sounds like a voice. For the first time, sitting next to Mr. Breaux, he had heard what clear voices, and they were saying something to the effect of, "You won't do it, you won't," in a sort of taunting like fashion. At that point, he grew even more paranoid and out of basically in a state of fear and paranoia. He told me that he then lunged at what he saw as a shadow figure. Well,
I'm gonna pause you there. Did he say anything about the knife?
is it all right if I just briefly, this is a very specific question, just briefly check my notes?
We're referring to your report, refresh your memory?
Yes.
I would refer you to page 26.
Yes.
Okay, go ahead.
Okay. He did.
What did he say about the knife?
So I asked him what made him take out the knife. He told me that he didn't remember.
Okay, may I first look at your answer?
Okay.
Here, right?
Sorry, I can't understand.
This is 26. Here.
This.
Sure.
Okay.
Okay.
You just pointed something particular, that's fine. So you can ask a question about it.
Yes.
And that's at page 26 of his report, I take it?
Correct.
Okay.
Did he say anything else about the knife?
He did. Earlier in this part of the report, he says that he grabbed my knife, meaning his knife, and lunged at him.
Okay, and so he specifically recounted having the knife and retrieving the knife.
Yes.
And so, later in the same interview, did you talk with him about, let me ask you this, did he say specifically, quote, "I started looking around and got paranoid, and got more paranoid when I saw a shadow figure sitting next to me on the bench"?
Yes.
And so when you were interviewing him, did you interpret that as being that he is on the same bench as the person he is referring to?
Yes, but I also didn't specify. I didn't think to ask if there were multiple benches in the park. We were referring to bench in sort of non-specific terms. And I think at various points during the interview, I don't know actually that I always had a specific understanding. To me, it sounded like they were in a park, there was a bench, they were sitting on a bench. But again, I didn't specify whether there could have been multiple benches or not. I didn't ask.
Thank you. And then specifically about the murder of David Breaux, did you ask him about the circumstances, or sorry, the murder of Karim Najm? Did you talk to him about that?
I did.
And I'm going to ask you a specific quote from page 27.
Okay.
Did he tell you, quote, "I went for a walk to Sycamore Park. I was on my way home when some dude just came into the bike path, and he was pointing in my direction and doing something weird and making a laughing gesture with his hand. That's when I remember, and I got in his way to see if he would stop, but we collided and he fell backwards and I fell the opposite way, and all I remember was lunging at him with the knife."
That's the exact quote.
And so when you, did you actually put that in quotes in your report?
Yes,
And so that's verbatim the language that he used.
it was verbatim.
And did he recount seeing a flashlight?
He did.
What did he say about that?
So he said that he next saw a flashlight and thought it was a, quote, supernatural being trying to, quote, to get him.
Did he say what he did after that?
He then, quote, yes.
What did he say?
He then, quote, grabbed the other guy's bike and left the park.
Other guys, are those the words that he used? Other guys.
Yes.
During your conversation with Mr. Dominguez about the incident at Sycamore Park, did he reference Karim Abu Najm as a shadow or a shadow figure, or did he strictly use the term supernatural or supernatural being?
In this case, he referred to supernatural being.
Did he describe seeing a shadow?
Not in this instance, he did not.
Did he describe seeing anything like a void in the area of Karim Abu Najm's mouth?
No.
Okay, I'm going to. Sorry. And then regarding what else he said about Karim Abu Najm, you can ask him specifically who he thought the person on the bike path was.
I did.
What did he say about that?
So he thought it was a, quote, supernatural being who was after me, end quote.
Did you ask him if he was trying to kill the supernatural being?
I did.
And what did he say about that?
And this is a quote. No, I just wanted him to go away.
Now, I want to talk with you about specific statements that Mr. Dominguez said regarding the stabbing of Kimberlee Guillory. On page 20. Did he say specifically, quote, "I'm out again for a bike ride and stopped at the railroad tracks at downtown Davis at a log when I decided to go for a walk. 2 seconds into my walk, I saw a shadow portraying from the tent that was signaling me to come closer, and I did. I was getting closer, and when I was a foot away from the shadow, or when I was a foot away, the hand of the shadow jumped at me, and that's when I got paranoid and scared and flinched. And the flinch was a stabbing motion. I heard a scream, and that's when I left to get my bike and went home."
That's the exact quote.
And when you asked him about this, did you ask him what he thought had happened at that moment?
I did.
What did he say?
He said, and this is another quote, "That time I wasn't sure. I thought that the supernatural beings were trying to get my attention again. This time I thought they were trying to scare me," end quote.
And did you ask him if he had thought he had stabbed another person?
I did.
What was his response?
No.
Did you ask him if he had thought he had stabbed a supernatural being?
Yes.
And what did he say about that?
No.
What did he say that he thought had happened?
He thought he had, quote, punched, end quote, the, quote, supernatural being.
Did you ask him if he saw any blood?
I did.
And what did he say about that?
He said that he did not see any blood.
I don't have any additional questions.
Okay, thank you, Mr. Vanderhook. Mr. Hutchison, any questions?
Dr. Weiner, if I were to do a word search for shadow in your report, how many times did Mr. Dominguez tell you about seeing the shadows?
Many times, more than 10 or 15.
Approach.
Okay.
Search for shadow. You're familiar with how you can do a word search in a document?
Yes,
I'm showing you, is this your report?
it is.
And did I appear to do a word search for the term shadow?
You did.
And how many times is shadow used in your report?
40.
And at times, Mr. Reales Dominguez would also refer to the shadows as supernatural beings.
Yes.
And did you in fact ask him if there was a difference between the shadows and supernatural beings?
Yes.
And he told you they're the same.
Almost correct. Can I explain?
Okay, go ahead.
So he told me that, in essence, that's correct, but it's a little bit more specific than that. So his some of his initial visual hallucinations that he told me about were shadows. They made him afraid or paranoid because they were shadows without an apparent source. Of course, when you see a shadow, you can typically track it to the object that's creating the shadow, but in his case, he was telling me that he couldn't do that, and so it was alarming that there was this sort of shadow that he couldn't see. And over time, specifically around the period of January and February 2023, a few months before the incident offenses, he began to, from my understanding, have a sort of delusional interpretation of the shadows, what we might think of as a delusional perception.
I'm sorry, what? Interpretation of the shadows?
What we might think of as a delusional perception, where he was seeing what was already a hallucination, the shadow, without a source, and then began to think that shadow was either a supernatural being or a shapeshifter, and he referred to those terms interchangeably.
And with respect to the stabbing at Central Park, when you first met with Mr. Reales Dominguez, he was fully medicated.
Yes.
At that point, he realized that he had actually stabbed people.
Correct.
He was no longer under a delusion or hallucination that it had been supernatural beings or shadows or shapeshifters.
That's right.
When you met with Mr. Reales Dominguez, at that point you had not been provided with any photos of the benches, or the bench where Mr. Breaux was found.
I believe that's correct.
And you saw from the prosecutor's question that he interpreted what you wrote as Mr. Reales Dominguez saying he was on the same bench as the shadow figure.
Yes.
But you never, that was not something you specified with Mr. Reales Dominguez during your first interview.
Admittedly, I didn't think to ask that question, so it wasn't specified in my evaluation.
Okay. Saying someone's on the bench next to me, you agree that could mean a couple of things.
Yes.
It could mean they're on the same bench as me, correct?
Yes.
It could also mean they're on the next bench over.
Correct.
And at some point prior to meeting with Mr. Reales Dominguez, the week after this trial started, the prosecutor sent you a cover letter making some purported statements of fact.
Correct.
And the prosecutor, I'm referring to Mr. Vanderhook, correct?
Yes.
You never spoke with Mr. Moore.
I did not.
Mr. Vanderhook gave you some materials that he contended supported his statements of fact.
Yes.
One of those materials was this quote that Mr. Vanderhook interpreted as Mr. Reales Dominguez saying that he was on the same bench as the shadow figure.
Correct.
And you were actually, by me, provided photographs showing the two benches at the scene.
I was.
And you went out and spoke to Mr. Reales Dominguez about this.
I did.
Again, he answered all of your questions.
Yes.
And he explained to you that the shadow figure was not on the same bench, it was on the next bench over.
That's correct.
And thinking back to your initial interview with Mr. Reales Dominguez, he didn't say anything that is inconsistent with that.
He did not.
Mr. Reales Dominguez also described to you that after lunging at the shadow figure, all of a sudden he saw a face.
Yes.
And he told you how the face scared him.
If I recall correctly, he described it as a, quote, neutral face.
Not a face attached to a body, just a face.
Yes.
And he talked about how he grew paranoid.
Yes.
And then that caused him to flee.
That's right.
Seeing that face scared him.
Yes.
And at the time you met with Mr. Reales Dominguez, you hadn't seen any photos of David Breaux as he looked when he was found by law enforcement, correct?
That's correct.
To this day, you still haven't seen any photos of David Breaux as he looked when he was found by law enforcement.
I was provided with some photos of the scene in the follow-up materials provided by the district attorney.
Did you finally see a photograph of David Breaux?
Yes, but if I recall correctly, he was partially covered. Yeah.
So you never saw photographs from the district attorney showing Mr. Breaux's face?
Oh, I see. No, I didn't.
So I'd like you to assume that when he was found, Mr. Breaux was completely covered in dark clothing from head to toe, with a hoodie pulled up over his head, and all that was visible was probably about 3/4 of his face.
Okay.
And that he was assumed he was found sitting on the bench facing out.
Okay.
Okay. That would be consistent with what Mr. Reales Dominguez told you, wouldn't it?
Yes.
I'd like to talk to you about when you spoke to Mr. Reales Dominguez about the stabbing that happened at Sycamore Park.
Okay.
The prosecutor asked you about Mr. Reales Dominguez's use of the term guy and dude, all that?
Yes.
And at the time you spoke with Mr. Reales Dominguez, he understood that he had stabbed a human being.
He did.
He understood that he had stabbed Karim Abou Najm.
Yes.
He understood that Karim Abou Najm would be considered a guy.
Yes.
So when he used those terms, guy and dude, was it your understanding that he was communicating to you that at the time he believed it was a human being?
No, and in fact, that's why I asked him later, just a few minutes later in my evaluation, who it was he had thought he stabbed.
It was clear to you that he was describing a shadow figure or a supernatural being.
Yes.
And he told you that this shadow figure was on a bicycle,
Yes.
was pointing at him,
Yes.
was making sort of a laughing gesture with another arm.
Correct.
He told you how he stepped in front of the shadow figure because he believed it would make him go away or go around it.
Yes.
And he described to you how scared he was.
Yes.
And you also spoke to him about the stabbing of Kimberlee Guillory.
I did.
And at that time, he knew that he had stabbed a human.
He did.
He understood that he had stabbed Kimberlee Guillory.
Yes.
But you were asking him to describe what he believed at the time.
Correct.
And he told you that he was at a log. He had been at a log.
Yes.
He told you he'd ridden his bike to the log.
Yes.
That he got up and started to walk.
Yes.
And then as he was walking, he saw a shadow figure in a tent.
Correct.
And the shadow figure gestured for him to come toward him.
Yes.
And then it then reached through and tried to grab him.
Yes.
And he told you how he flinched and thought he punched through the tent.
Yes.
Now, and Mr. Reales Dominguez told you specifically he thought that he had punched.
Yes.
And in that cover letter that Mr. Vanner had sent you, he asked you to consider the fact that he said there was not a puncture hole in the tent. It was in fact cut from top to bottom. You remember Mr. Vanner telling you that?
I do.
Okay. So, and at that time, that was your understanding of what the evidence was, correct?
Yes.
And you went out and spoke to Mr. Reales Dominguez about that?
I did.
And he still maintained that his memory was he punched through it.
Yes.
He had no memory of cutting the tent down and sideways.
His story was consistent.
But then once the trial started, you received some information about the testimony of a man named Isaac Chessman, correct?
Yes.
And you received evidence that Isaac Chessman described that when he first saw the hole in the tent, it was a puncture the size of a tissue.
Correct.
And you received evidence that whoever cut that tent did it after the fact.
Correct.
So what Mr. Reales Dominguez told you, both the first time and when you came out the second time, that he maintained it was a punch, that is completely consistent with what Mr. Chessman testified to, correct?
It sounds like it, yes.
And once again, you confronted Mr. Reales Dominguez with the fact that the tent had apparently been cut, correct?
Yes.
And he still maintained, he just remembers punching through it.
Yes.
And sir, after you met with Mr. Reales Dominguez and you consider all the materials the prosecutor provided to you, did that change your opinion in any way?
It did not.
I have nothing further. Thank you, sir.
Okay, thank you. Any follow-up, Mr. Van Hook?
Sir, just regarding your interview with Mr. Dominguez, regarding killing of David Breaux, from that interview, were you under the impression that they were on the same bench?
Yes, I was under that impression. Although I'd like to add that I was thinking very little about their positions. If I had to pick whether there's one or two benches, I probably would pick that there was one bench. But it certainly wasn't a topic I explored in any detail. And so, like I said before, I didn't ask if there were multiple benches or anything like that. I was trying to more so understand Mr. Dominguez's state of mind, what he was experiencing in that moment, as opposed to his sort of precise position as far as he remembered it at that time.
Regarding the killing of Karim Abou, did the defendant tell you specifically why he got in the way? What was his statement about why he got in the way?
I'm sorry, who got in the way?
Why Mr. Dominguez got in the way of Mr. Karim Abou?
He said, and this is a quote, "I got in his way to see if he would stop."
And regarding the stabbing of Kimberlee Guillory, when he talked to you about going for a walk, did he mention only one walk or did he mention multiple walks?
It appears that he mentions the walk that he's taking in the moments before the event.
Okay, and then regarding your, so there was questioning about your subsequent interview where you clarified his statement about the tent. Do you have your notes on that?
I do.
Objection to state's testimony.
Rephrase.
Okay.
Just ask him, you want to draw his attention to the testimony regarding the tent. Okay.
So, and I want to talk to you specifically about your most recent interview with Mr. Dominguez about what happened at the tent. Okay?
Okay.
Do you have your notes on that?
I do not.
Without your notes, do you remember exactly what was said there?
I couldn't provide direct quotations, but I remember approximately what was said.
And if I show you your notes, would that refresh your memory?
Yes.
Any questions?
Yes.
So from page 6 of the document, we're just pointing you out to the second paragraph from the top.
Can I start where it says comments?
Well, if you just read it to yourself for now,
Okay.
and you can start wherever you want to refresh your memory.
Sure. Okay. Thank you.
And is your memory refreshed?
Yes.
What did he say specifically about whether it was a punch or a cut? What did he say about that particular movement?
He said he, and these are quotations as far as I can tell, that he kind of like punched it. He then described it as so it was like a slashing motion, but also like a punching motion.
Thank you. I don't have any additional questions.
Okay. Alrighty then, Mr. Hutchinson, we're done?
Yes, one question. When you spoke to Mr. Reales Dominguez,
Yes.
had Isaac Chesterman testified yet?
Not that I recall.
What day did you speak to Mr. Reales Dominguez?
I believe it was May 3rd.
On Saturday.
Yes.
I have nothing further. Thank you, sir.
Okay, great. All right, Dr. Weiner, thank you for your testimony. Have a great day.
Thank you.
I appreciate it. Super. Counsel, sidebar, thank you. Off the record, feel free to stand up and stretch, folks. Okay, Mr. Vanderhook, do you have a witness you'd like to call?
Let people call Gene Lyon.
Okay, let's get this file. Good morning. Good morning again. Come on in. We're going to go through the same process that we did. We'll have you sworn in, take the oath, and then the witness stand. Thanks.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the cause not being for the court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. State your first and last name for the record, and spell them both.
Jean Lyon, Jeanlyon.
Okay, thank you. Mr. Vanderhook, direct.
Morning, ma'am.
Good morning.
Can you remind us again what your job is?
The Deputy Director of Police Services at the Davis Police Department.
Can you know what a catalog is?
Yes.
What's a catalog?
A catalog is a record of an incident, of either a call for service or police contact, or any kind of recording of anything noteworthy that occurs at the police department.
How is a catalog different from a police report?
A catalog is usually something that records a call for service where either somebody from the community might call in and report something, and the dispatcher notes what's being reported, and we dispatch an officer to it. Doesn't necessarily mean an officer took a report that is submitted to the district attorney's office. It's simply something that might be reported to the police department.
Okay. And so if an officer contacts a person on the street,
Mhm.
could there be a catalog for that?
It's possible, yes.
Under what circumstances would there be a catalog?
If an officer makes contact with somebody, a pedestrian stop or a car stop, and calls that into dispatch, they create an incident, which is also it creates a catalog.
And can the officer create the incident themselves outside of calling it into dispatch?
It's very unusual for that to happen. I believe, I don't believe they can do that from their MDCs. That's something that dispatch does.
Understood. So this typically requires the officer to call it in on the radio.
Correct.
And so if the officer didn't call it on the radio, would there be a catalog?
No.
And how long are catalogs retained for?
Right now, we retain them since the inception of our CAD system. We have them going back quite far, 2006, April.
So you have all the department's catalogs from 2006 to present.
April 2006.
Understood. And so, if an officer does a stop of a person, whether on foot, car, bicyclist, whichever, and they radio it in, there should be a catalog for that.
Yes.
Would there be a catalog even if the officer never checked the person's name through dispatch, like they never ran a name check?
Yes.
Right, that's good.
Okay, thank you, Mr. Vanderhook. Mr. Hutchinson?
May I make a clarifying statement?
Yes, clarify your answer.
There are times if they are assigned to an incident that's already occurring, meaning they're on scene of a large incident and they contact people within the scope of that incident, that it might be logged to that occurring incident, if that makes sense.
May I ask some follow-up questions, Your Honor?
Okay, it's not really relevant. I mean, we don't have a follow-up incident in this case, right? I think she was just qualifying, and her qualification didn't seem relevant to me, but go ahead.
Can you explain? I didn't fully understand that.
I understand. Can I speak in hypotheticals?
Sure, please.
Okay, let's say we have a major incident, let's say a major traffic accident, might be, let's say, drunk driving accident, and they're looking for a suspect in the area. They might, and this incident lasts an extended period of time, 2 hours or something, and they contact a driver a block away, or several drivers within that period of time. Those contacts would be logged to most likely a singular incident, but it is possible that there would be other incidents related to it, if that makes sense.
So they would be noted in the original incident rather than having their own separate catalog?
It could happen either way.
Understood. Nothing further.
Okay, Mr. Hutchinson, anything?
Yes, sir. Good morning, Ms. Lyon.
Good morning.
So if an officer has brief contact with a person, asks them their name, and then tells them you can go, and never calls that into dispatch, is there going to be a catalog of that?
If they don't call it into dispatch, no.
I have nothing further. Thank you.
Okay, Ms. Lyon, thank you for coming back to court. Have a great day.
Thank you.
Thank you. Okay, ladies and gentlemen of the jury, I think we have, at this point, we have one more witness I'd like to hear from. And and we're gonna do that at 1:30, all right? So you're off until 1:30, and expect a full afternoon of evidence, and then we're gonna move on to additional phase of this trial. So I want to underscore and maybe remind you of our three-part admonition. And it's critical that you not watch any news coverage of this case, not read any blog posts or any social media accounts. It's important that you not initiate any conversation with each other regarding the substance of this case, with anyone regarding the substance of this case. The only matter, and you should do it only on an as-needed basis, is to discuss the schedule. Don't discuss the case other than that. I do understand sometimes you have to tell work that I'm in the trial, it's ongoing, and the judge has given us this amount of approximate time. So when I say you can discuss the schedule, it's really in a limited way and as needed. Absolutely do not discuss the merits of this case with anyone. And what you've seen, and don't watch any TV, pick up newspapers, tell the people in your household, don't bring any of this up to me, okay? They should know that by now. So it's also critical that you not go by the scene of any incident described in testimony here. If you incidentally go by, don't stop and look, don't examine and so forth, right? That goes into do not research this case. Don't go on your phones, the internet and so forth and look up names, even out of curiosity. Maybe you heard a name from one of the experts regarding something medical. This isn't the time to research it. You're going to rely on all the evidence you have here and not information that you get outside of court. Absolutely important. So I have reminded you at each break of the three-part admonition. If you have any concerns or anyone approaches you, you need to say, I can't talk about this, and you need to note that contact on a note and give it to the bailiff and let me know, and I'll deal with it. And so I shorthand these rules. I think I've referred to them as a three-part admonition. Don't discuss this case other than scheduling. Don't form any opinions about this case, and don't research. I do want to remind you about not forming opinions. When you go into the jury deliberation room, each of you will exercise your independent judgment and discretion. You will be advised that we want you to try to reach a verdict. I'll give you a full detailed explanation of that. But it has to be your verdict individually. There's a process for deliberating. You need to keep an open mind and listen to your fellow jurors. And if they convince you to change your position, then you will change your position based on a rational explanation that you then become convinced of. Okay? And I'm going to give you very detailed instruction on that. Now is not the time to think that you've got the case figured out or you know how you vote. That's not where we're at. Even though we're getting close to the close of evidence, you still need to know what the law is. You don't know what you're judging the facts on yet, because I have to give you the substance of the law. And then we, of course, want the lawyers to present their closing arguments to you, so you can understand what they believe the facts show and how they think that plays out with the law. So just keep an open mind at all times, as I've indicated. I feel the need to just reiterate that from time to time during the trial, and today was a day I just wanted to underscore that one more time. So thank you. I refer to these general rules as a three-part admonition. Sometimes I repeat them, and sometimes I don't. But it's so important to me that I say it at every break, and it's the rhythm of the job. It's like when we start at the beginning of the day and we come together and we rise. Part of it is every break, understanding that those rules are just critical to justice. So anyway, thank you for your patience with me as I explain it one more time. And so don't forget the three-part admonition. Enjoy your break. I'll see you at 1:30. Thanks, folks. On the record in People v. Reales Dominguez. And Dr. Reed, it's good to see you again. I'm here, all counsel. I have the jury. You were in my courtroom, probably know there's a big screen there, and we can see you perfectly, and you're looking me right in the eyes of all of our 16 jurors. So thank you for being here. Thank you for making time. However, something short came up, and I need you to sit in my waiting room for 10 or 15 minutes, okay? And yes, and I don't expect your testimony will be that long today, but I appreciate your patience. Let's make sure I can see you fine, and we'll probably dim the lights to see you even better, but I want to check your audio real quick. How are you doing today?
I am doing okay, thank you for asking.
Okay, I need to turn up the volume a little bit on her. Do we have the ability? I heard it, but I want to get it a little higher. Okay, try again. Say something unrelated to this case that's not controversial.
I just wanted to say that thank you for allowing me to testify remotely today.
Thank you, and the parties agreed to that. So that's great, and now I can hear you perfectly. So I am going to put you into the waiting room for 10, 15 minutes. Okay, thank you.
Okay, thank you.
All right, so next up is we have an additional witness, and I understand the prosecution will call this witness Mr. Vanderhoek.
People call Janelle Bestpitch.
Is that your sergeant?
Yes.
Yes, right. Thank you. Thank you for making time for us this afternoon. We're going to go through this process.
You do solemnly swear to not to give, and the cause not be for the court, shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please be seated. State your first and last name for the record. You spell them both.
Janelle Bestpitch, JANELLBESTPITCH.
Okay, thank you. All right, Mr. Vanderhoek.
Thank you, good afternoon, Sergeant.
Good afternoon.
Sergeant, related to Davis PD records, are you aware that searches were conducted of Davis PD records and other agencies looking for catalogs related to the name John Joas?
Yes.
And related to the name John Joas, were any records found?
No.
And so on either Monday or Tuesday, are you aware that there was a request made to look for catalogs related to bike stops or pedestrian stops in the area of Central Park in Diggs?
Yes.
And did you talk to me during the lunch break about this?
Yes.
And was the record found?
Yes.
And I have here with me Smartest People's Exhibit 106. Did you look at this just before court started, before the jury came in?
Yes.
And is this the record that you alerted me to during lunch?
Yes.
So, may I publish?
Yes.
And so, what, Sergeant Bestpitch, what is this?
That is a printed out version of our CAD incident reports.
And what does it show us?
It shows us the location of the stop, the time, the date, the officer, what type of stop it was, and the disposition of the stop.
Why don't we do this? The jury can't really see what's been published. So,
Sorry.
yeah, focus in. And I think you do have a laser pointer. As the lawyers ask questions, feel free to work through the document with the laser pointer.
Will do.
Well, let me ask you some foundational questions. This document, is it produced in the regular course of business at Davis Police Department?
Yes.
And is the record produced at or near the time of the events reflected in the incident?
Yes.
And how do these records come into existence? Like, how are they made?
When anytime an incident happens or an event happens, a report gets generated. This type of report gets generated, not necessarily a written police report.
All right, and this would be something like an officer radios in a call?
Yes.
And so, for location here, we have B Street and 3rd Street. Do you see that?
Yes.
Is that in the city of Davis?
Yes.
Is that right by Central Park?
Yes.
Is it the east or the west side of Central Park?
It would be more the,
Well, I'm gonna pause you.
sorry, yes.
Is that the southwest corner?
And here it's been marked
Yes.
for identification purposes, People's 25A. Zooming in here on Central Park, can you see where B Street and 3rd Street is in relation to Central Park?
Yeah, it's that southwest corner of Central Park.
All right, and when did this event take place?
It took place on March 28th, 2023
And what time?
at 10:17 a.m.
And so what type of incident was this?
It was a bike stop.
And going down, can you see what officer conducted this bike stop?
It would have been Officer John Ney based on the unit number right there and his badge number.
And does Officer May still work for the police department?
He does not.
And why is that?
He is retired.
And so here, for persons, what does that mean?
That would be the name of the person that he contacted.
All All right, and what is the name here?
Joseph John.
So Joseph is the first name, John is the last name,
Yes,
and does it give a date of birth?
it does, of October 10th, 1999.
So let's go down to the bottom of the log here. What does this bottom portion mean where it's talking about time and event and that sort of thing?
So the top portion would be when the incident was created, and then where it says 523
Well, I'm gonna pause you there. At the bottom, what disposition AD, what does that mean?
means advised.
All right, and so then this bottom portion, what does that mean?
It has a different date because we're required to do stop data logs. So anytime we detain somebody or stop them, we have to state a reason for it, ethnicity, and then what was the disposition of it.
And here, this information as far as name and date of birth, would that have been entered at the time of the stop or at a later time?
Would have been entered at a later time.
And so this is not something that was given to dispatch at the time of the stop.
Correct. On the right side, you can see it was entered by Officer Ney, by his.
And so this portion where it says where it's entered by, who's it entered by there?
That would be on a dispatcher with the D in front.
No further questions.
Okay, thank you. Mr. Hutchinson?
Good afternoon, Sergeant Bestpitch.
Good afternoon.
So, just to be clear, if you could show what's been marked Defense Exhibit UU.
Is this a different document?
No, it's a map.
Oh, okay, I'm sorry. Thank you.
So, this document indicates the stop was the location, it says B Street / 3rd Street.
Yes.
That would be, means it's in the area of the intersection of B Street or 3rd Street, right?
Yes.
You can see Central Park here,
Yes.
and this would be B Street.
Yes.
And were you here when Mr. Reales Dominguez was testifying when he was contacted by this officer?
Yes.
Did Mr. Reales Dominguez said he was on B Street on the west side of Central Park?
Yes.
And when the Davis Police Department started looking for records of a John Joas in January of this year, had Officer Ney already retired?
Yes.
When did he retire?
I don't know. It's been a little while.
Officer Ney, though, was he white or did he appear white?
Officer Ney was white, yes.
And he was a man?
Yes, he was a man.
And did Davis PD have SUV patrol vehicles at that time?
We did, yes.
Do you recall Mr. Reales Dominguez testifying that he was stopped by an officer in a SUV
Yes.
who was white,
Yes.
who was a man?
Yes.
Do you recall Mr. Reales Dominguez saying this happened approximately about a month prior to the incidents?
Yes.
And so Mr. David Breaux, his body was found on April 27th.
Yes.
Oh, sorry. Showing back People's Exhibit 106. So Officer Ney, he stopped this individual on March 28th of 2023, correct?
Correct.
Almost exactly 1 month prior to Mr. Breaux being discovered in Central Park.
Yes.
You recall Mr. Reales Dominguez saying he was on a bicycle when he was stopped?
Yes.
This record indicates that the person Officer Ney stopped was on a bicycle.
Correct.
And you recall Mr. Reales Dominguez saying that it was extremely short contact, less than a minute?
Yes.
This document shows the length of the length of the contact, correct?
Yes.
So on scene at 10:17 and 40 seconds, that means that's when Officer Ney contacted this John Joseph or Joseph John?
It's usually within like a minute. It depends on the officer, but yes, that's generally correct.
But according to Officer Day, this whole contact lasted approximately 37 seconds.
Correct.
That is consistent with what Mr. Reales Dominguez testified to.
Yes.
And this is listed under the name Joseph John.
Correct.
That means Officer Ney, when he heard a name during this 37-second contact, he thought he heard the name Joseph John. Or that's what you would infer from this, correct?
That's what I would infer, yes.
But if you can assume that this person actually said his name was John Joas, and Officer Ney heard John Joseph, he would be the one putting in the name, correct? Officer Ney would be typing in Joseph John.
Officer Ney did that, yes.
So this just indicates what Officer Ney typed in, not necessarily what the person actually told Officer Ney.
I would presume that.
But you, as a law enforcement officer with so many years of experience, sometimes people tell you a name and you don't hear it correctly the first time. You've had that experience, right?
That could be true, yes.
And with John Joseph, those are both first names. They can both be first names.
They can be, yes, sir.
And you would agree John Joseph sounds similar to the name John Joas. You would agree with that?
They are similar with the J's, yes.
Now, you heard Mr. Reales Dominguez testify. He did not recall giving the officer his birthday,
Correct.
but it appears this person did give Officer Ney the birthday.
Correct.
And he gave a birthday of October 10th, 1999.
Correct.
Can you remind me again, what was the birthday that Mr. Reales Dominguez gave when he was first contacted by Officer Story?
I believe it was very similar to that. I can't remember
Was it similar,
exactly.
or was it that exact birthday?
Sorry, I don't recall. I'm sure you're correct.
And Davis Police Department has been trying to find records regarding this contact since January of this year, correct? When were you first asked to look to find records of a John Joas?
I think it was a while ago, and then I believe again in January, and then again just a couple days ago when we had more information. At least this is the first I've heard that it was a bike stop and where it was at.
Well, you knew it was a bike stop prior to Mr. Reales Dominguez testifying, correct?
I did not know.
But assuming Mr. Reales Dominguez gave Officer Story the name John Joas with a date of birth of 10/10/99, did you ever just run that name through and that birth date and see what popped up?
I personally did not know.
So if you were to put into the catalog John Joas with 10/10/99, would this pop up or no?
No, the only thing that pops up is John Joas, which was Carlos Dominguez.
So in order for this to pop up, you have to have the exact, during a search, you have to have the exact name and the exact date of birth.
On some searches, other names pop up, but that would be very common, so you would get a whole bunch of different results if that was the case. But with the John Joas, because we had an exact match, then that was the only thing that pulled up.
And you said you conducted this search at the request of the prosecutor, Mr. Vanderhoek,
Yes,
and your goal was to find that there is no contact with a John Joas, and then that was what you would testify to, correct?
no.
What was the purpose? Did Mr.
To do more of a, when I went to records, I can't remember what day it was, Tuesday, I guess. I gave them more of a parameter to look for when they were asking for the records. And they did a lot of digging, and one of the records supervisors found this.
Was your goal to confirm that Mr. Reales Dominguez was telling the truth, or was your goal to try to confirm, as the prosecution's theory, that he was lying about this prior incident? What was your goal in doing this?
Our goal was to do a thorough check.
And you just found this just today?
Yes, the records supervisor found that today.
At what time?
I was told to give them a phone call when I was on break, which happened around noon today.
And then you forwarded it to Mr. Vanderhook?
I let Mr. Vanderhook know, yes.
And you understood that, given the nature of this evidence, he would be required by law to give it to me?
Yes.
It also says the race of this person is white?
Yes. I think you have to pull it down a little bit more. There you go.
Thank you.
Yes.
White. You would agree that perhaps in just a brief 37-second contact, Mr. Reales Dominguez, although he's Latino, well, he could be identified as white. Latinos can be identified as white, correct?
That's correct.
Mr. Reales Dominguez does appear to be light complexion.
Yes.
Did anyone actually call Officer Ney? He's still around, isn't he?
I'm assuming he is, yes.
Did anyone call and ask if he remembers this?
In the last 2 hours, no.
Nothing further, thank you.
Okay, Mr. Vanderhook, any follow-up?
Nothing.
Okay, Sergeant Bestpitch, thank you for your testimony.
Thank you.
Okay, we have a witness waiting. Let's bring in Dr. Reed. Okay, good afternoon again, Dr. Reed's Judge McAdam. Can you hear me okay?
Yes, I hear you okay.
Thank you. I am going to go through the same process of having the clerk swear you in. After you are sworn in and you spell your full name, then we'll have two lawyers to ask questions. Okay, Mr. Clerk, go ahead.
Please raise your right hand. You do solemnly swear this plea about to give in the cause now open to the court, show me the truth, the whole truth, and nothing but the truth?
I do.
Thank you. State your first and last name for the record and spell them both.
First name Serenity, S as Sam, I as India, R as Robert, I as India, N as Nancy, T as Tom, I as India, P as Paul. Last name Reed, R as Robert, H as House, E as Edward, E as Edward.
Thank you. Mr. Vanderhook, your witness.
Good afternoon, Doctor.
Good afternoon.
When you interviewed Mr. Dominguez, did you talk to him about a prior police contact he had where he used the name John Joas?
I did.
And did you document that in your report?
I did.
And did you get a cover letter from my office, specifically for me, addressing that issue?
I did.
And did the letter talk about the use of the name John Joas?
Yes, that is correct.
And in fact, it included attachments as well, correct?
I'm trying to think back. Yes, that is correct.
And specifically, the records were subpoenaed documents, correct?
Objection, outside scope, facts not in evidence.
This is related to the contact that we just had heard evidence about. So I'm gonna, it's
This witness?
it's new. If he's asking about what the defendant told the doctor about this contact, I'm gonna allow it, given the new information that's come to light.
Right, that's not what he's asking about.
Oh, I'm sorry, I thought we were still on that, I missed it.
No, he wants.
Can we approach?
Okay, so the area of inquiry, just a moment, folks. The area of inquiry, I would allow testimony regarding Sergeant Bestpitch's testimony in that exhibit. So that area for Dr. Ree is okay, and the statements made by the defendant as to the 3 crimes, that area is okay. I've approved that area of inquiry. So yes, so try to cover that, and then if you want additional coverage, then we will take a sidebar then.
You know, I think the jury may not be able to see Dr. Reed well with the light.
Oh, yeah, thanks for reminding me. Thanks. Okay, so with that guidance, you have material to cover.
Well, on this issue, I've reached the point where I would either need to switch to a different topic or approach on this issue.
I just identified 4 areas of inquiry. If you have questions on those 4 areas, then I would like you to proceed. If you don't, then we're done and I will take a sidebar.
And so, doctor, specifically, it included records that showed that every law enforcement agency...
Objection, facts not in evidence.
Okay,
Outside scope.
sustained. I thought we were going to talk about the 3 statements by the defendant regarding 3 crimes, and then I would allow the testimony regarding what we just heard from Sergeant Bestpitch. Those 4 areas are fair game.
Understood. Thank you. So, I want to ask you specifically about the offenses here, and Mr. Dominguez's statement to you about each of the offenses. Okay?
Okay.
And so, specifically, when you talked with Mr. Dominguez about the stabbing of David Breaux in Central Park, he gave a statement to you about that, correct?
Yes.
And specifically, he told you that he heard a voice that said, "You won't go up to him, you won't."
Objection, leading.
Okay. Just for the convenience of I'm going to allow. Is this in quotation in the report?
No, she's written in summary, so I think.
Okay.
This part's in quotes.
Okay. You can quote her the questions directly. Otherwise, you have to use your tools on direct. Who, what, when, where, and how.
But the voices said, quote, "You won't go up to him, you won't, end quote.
Yes.
And what did he tell you that he saw after that?
I believe he said that he saw a shadow on a bench
And
in the park.
did he specifically say that he saw the shadow next to him on the bench?
From my memory, I remember he said that he saw a shadow next to him on the bench.
And was your understanding of the statement that he was talking about that shadow being on the same bench as him or on a different bench?
I did not ask about that because I did not think that it was an important issue to talk about that. However, when I met with you, I believe last month, I did ask you about the bench. I asked about, are there any other benches next to where he was sitting? And your answer helped clarify that issue.
Because there is other benches there, correct?
Yes.
And did he tell you specifically that after seeing the shadow next to him on the bench, he grabbed his knife?
Yes.
And did he tell you that he went up to the shadow?
I
Your Honor, I'm objecting.
Sustained.
These are not direct quotes.
Sustained. Direct examination tools at this point. Direct quotes, you can lead with that question.
What did he tell you he did after he grabbed the knife?
believe he said that Then he grabbed the knife and he saw a face, and at that point he felt paranoid and he was scared. And then after that he got blank out. I would like to add that I believe he was severely psychotic at the time. So based on my training and experience, anything that the person who is in the middle of a psychotic break say, we cannot expect that everything would be coherent minute by minute.
Understood. Thank you, doctor. And did he say what he did after he blanked out?
I believe he said then he left and he went home.
And specific to the stabbing of Karim Abou Najm in Central Park, did you talk with him about that?
I did.
And did he tell you when he got up that day?
I believe it was in the evening.
All right, would referring to your report refresh your memory?
Yes, that would help.
All right, and I would
Thank you.
I'd reference you to page 16.
Thank you. Yes, so he woke up around noon.
And did he say where he went after that?
He went to the park to try to get rid of the whisper. A little background to that is that he was telling me that around that time he was having or hearing a lot of whispers or the voices. So every time that happened, he would try to leave his house. He would try to go outside to get rid of the whisper. So to me, he was in distress from the hallucination. So he was again left the house and tried to cope with the symptoms.
And did he tell you that he went back to the park just once or more than once that day?
I believe more than once.
And did he say what he did in the park?
The first time he went to craft something on the tree and also cut through the knife at the tree.
And he said that the carving on the tree and throwing the knife at the tree was the same day.
Objection leading.
What day is he telling you that happened on?
He said that it happened that day during the second incident day. However, as I mentioned earlier, his memory might be fragmented and incoherent because at the time he was actively psychotic.
Understood. And at the time that you're conducting this interview, when is it that you're conducting this interview?
It was about 6 months ago. I conducted the interview early December 11
Understood. So
of last year.
So he'd been medicated for about a year and a half at that point.
Yes.
And so, did he tell you specifically what happened between him and Karim Abou Najm?
Yes, he said that he saw somebody, and at the time his understanding was that that somebody was a supernatural being coming toward him, and he said that someone or the supernatural being was laughing at him, making fun of him, and making some gesture. So he went up there to the figure, and then they collided at some point.
So,
He said,
So I'm going to pause you there because we're going to do it in questions and not just a narrative. This person that he saw, did he indicate how they were moving? Were they like walking on a bike, in a car, anything like that?
I do not recall specifically. May I refresh my memory by looking at my report again?
With the court's permission?
Okay.
Thank you. Okay, so he said that he saw someone walking with the backpack and pointing and laughing at him.
Right, and so what did he say after, you mentioned colliding, what did he say happened after colliding?
He said that he fell backward and whoever that was fell backward as well.
And what did he say happened after that?
So after that, he believed that that figure or that someone was a supernatural being coming after him. So he grabbed his knife and then he lunged at that figure.
And what did he say happened after that?
So after that, he said he was scared and he saw a light and he thought that there was a supernatural being again coming at him. So he got more paranoid, he was scared, so he took off.
Did he say anything about grabbing your bike?
Yes, he did.
What did he say about that?
He said he grabbed the bike and then he took off, but at some point he left the bike somewhere.
And what did he say happened after he left the bike somewhere?
I believe he went home.
Did he say how he got home?
I do not recall specifically.
Would your report refresh memory on that point?
Yes. He said he walked back home.
Now I want to direct you to the stabbing of Kimberlee Guillory. Did he provide a statement about the stabbing of Kimberlee Guillory?
Yes, he did.
What did he say happened there?
He said that on that day he was again hearing the whisper or in my opinion, he was having auditory hallucinations. So at that point, he went out to try to get rid of the whispers again. This time he did not go to the park, but he went to a train track. Then he saw a shadow.
So I'm going to pause you there. Did he say what happened at the train track or anything to that effect?
He said that he sat down for a little bit and then he went on a walk.
Okay, and did he say where he went?
He did not.
All right, what did he say about the walk?
So he said he went on a walk and he saw the shadows telling him to come. And it was calling him to go to the shadow. He said he was paranoid and scared because it was the first time that the shadow instructing him or commanding him to do something. So he got really paranoid at that point, and he said the shadow came at him and the shadow kept reach out to him. So he saw that the shadow was in the tent and he stabbed the shadow in the tent. And then he heard a scream and he got more scared and paranoid, and then he left.
And did he say how he got home?
He said that he got on his bike and went home.
So I've reached those 4 areas, Your Honor.
Okay, and so there's another area you'd like to go into?
It's related to the first area.
Okay, I'll hear argument, sidebar. Thank you. Off the record. Feel free to stand up, stretch, folks. Thanks. That was helpful, counsel. And so I have provided a scope of inquiry for counsel. And Mr. Vanderhook, continue on. We're on the record, as I didn't clearly say that. And continue on with your direct of Dr. Reed at this point.
Thank you. And Dr. Reed, I want to talk to you a little bit more about the use of this name, John Joas, and the circumstances around that, okay?
Okay.
So after you issue your report talking about the name John Joas, you got a letter from our office, written by me, about looking into the name John Joas, correct?
Yes.
And so did it include records in addition to the letter itself?
Yes.
And so what were these records about?
It was about police contacts in the area around that time to see if there were any contacts that include that name.
And did it include just John Joas, or did it include variations on John Joas, like variations on spelling, variations on the last name Joas versus Jonas? Did it include all the kind of different variations that could exist with that?
It included multiple versions of that names.
And were these records from multiple law enforcement agencies?
Yes, that is correct.
And so did it include the Yolo County Sheriff's Office,
I believe so.
the CHP,
Yes.
the Davis Police Department,
Yes.
the UC Davis Police Department,
Yes.
California Department of Fish and Wildlife.
Yes.
And so these records then were all looking at whether or not there had actually been a prior use of the name John Joas, or a variation of that.
Can you repeat the question? Sorry, your voice got cut off.
Did the records all look at whether or not there was a use of the name John Joas in any of the catalogs?
Yes.
And so, based on your review of the records, were there any records that you could see that showed a prior use of the name John Joas?
At the time, not yet.
Understood. And so, in the cover letter, you have the cover letter, and then you have all the exhibits that you got, correct?
Yes.
And the cover letter indicated that there was no prior use of the name John Joas?
Yes.
In fact, it said the prior use of the name John Joas was false.
I do not recall specific sentence, but I believe the meaning is the same, yes.
All right. Over the lunch hour, did I send you a new record that had been located?
Yes.
And did that record, was that a catalog from the Davis Police Department?
Yes.
And,
Oh, she can't really hear you when you step away from the mic.
sorry.
That's all right.
And so was this a catalog showing that there was a contact with someone using the name Joseph John in March of 2023?
Yes, that is correct.
And so you got that today during the lunch hour?
Yes.
Now I want to ask you, when you got the cover letter describing that there was no prior use of John Joas and giving you all the subpoenaed records from all the agencies checking for the use of the name John Joas, did that change your opinion at all from what it had been previously?
That did not change my opinion.
All right, and when you got this new document showing the use of the name Jonathan John, or, so let me get this right, Joseph John, did that change your opinion?
No, it did not.
All right, and so, were you swayed in either way? In either case, were you swayed to change your opinion?
On the first case, the first incident, At first, when there was no names came up, I remember that I had a meeting with you and I asked clarifying question. I asked you about if there were other police contacts. Was there a possibility that they may not run the name or they may not record that contact? And you informed me that there was a possibility, so that clarified my question at the time and my doubt. So that's why I concluded that my opinion did not change. And for the second record about this issue that I received today, it just confirmed my opinion.
Okay, no further questions.
Okay, thank you, Mr. Vanderhook. Mr. Hutchinson, do you have questions for Dr. Reed?
Yes, Dr. Reed, can you hear me?
Yes.
This cover letter that Mr. Vanderhook sent you, did he just send you materials or did he make statements about what, in his opinion, the materials showed?
They were both. There were both materials and also some statements.
And he wrote you this letter after you had already written your report.
Yes, that is correct.
After you'd already submitted your opinion to the court.
Yes.
So it was your understanding he wanted you to review these materials to see if it would change your opinion.
Yes.
And he sent you these subpoenaed records and he told you that subsequent investigation had shown that Mr. Reales Dominguez's claim that he had met an officer and given the name John Joas, he told you that was, quote, false, correct?
Yes, I believe so.
So he didn't just tell you we can't find records. He asserted definitively that the claim is false.
In that cover letter, yes.
Do you remember him using that phrase, the claim is false?
I recall it vaguely, so for me to able to remember it exactly, I would have to look at it again.
Do you have your email up in front of you?
I do not have the email, but I have it printed out. Is it okay if I just turn around and grab the document?
Yes, go ahead.
Thank you, Your Honor. Okay, I found the cover letter.
I'd like to direct your attention to paragraph 4. Do you see that?
Yes.
And in that paragraph, Mr. Vanderhook wrote to you, Mr. Dominguez claimed that a month prior, the police stopped him while he was riding his bicycle in the Davis area, and that he told the police the name, quotation mark, John Joas. Subsequent investigation has determined that that claim is false. Is that what Mr. Vanderhook told you?
Yes, in the letter.
And based on your review of the Davis CAD incident report that you received today, in your opinion, was Mr. Reales Dominguez's statement to you, was that false or was it true?
I believe it is true.
Now, Mr. Vanderhook also, in his cover letter, told you about cuts to the tent in which Miss Guillory was stabbed. You recall that?
Yes.
Sustained.
You went into the letter.
Only on the subject of John Joe S. You had an opportunity on that.
Even, Dr. Reed, even before you received this document, none of the materials that Mr. Vanderhook sent to you, and none of the assertions he made in his cover letter, did any of that cause you to change your opinion?
It did not.
Okay. Yeah, just remember, we got 4 narrow areas.
I understand. Dr. Reed, you indicated that in writing reports, you are trained to be concise.
Yes, that is correct.
And so, when you summarized Mr. Reales Dominguez's statements to you, you wrote them in summary. Would that be a correct statement?
Some parts are in summary and some parts are direct quotes.
And when you are trying to quote him exactly, you use quotation marks in your report.
Yes, that is correct.
So if you use quotation marks, that indicates those were his exact words.
Yes,
If you don't use quotation marks, that indicates you are writing what he told you in summary.
yes.
I'd like to
How,
Go ahead.
I'm sorry. There would be 2 times that it would be direct quote. The first one, as you mentioned, would be in the quotation. The second one would be if I indent it. That usually direct quote. However, when the person says something very long, in an attempt to be concise, I would not include everything. I would include the part that are direct quotes, but also important.
Now, do you have your report in front of you?
Yes,
I want to talk to you about what Mr. Reales Dominguez told you during your meeting about the first incident in which David Breaux was stabbed, okay?
okay,
And when it's a direct quote, I'll ask you to identify that, okay?
okay,
Mr. Reales Dominguez told you that he went on a bike ride to downtown Davis.
yes,
He told you he was riding his bike around for a couple hours.
yes,
He told you he stopped at the park.
yes,
He told you he sat down on a bench.
yes,
He told you he started hearing voices.
yes,
He told you it was the first time he heard voices saying something clearly to him.
yes,
He told you that usually he would only hear whispers and he couldn't understand, but that day he heard voices for the first time.
yes,
And then he told you what the voices said.
yes,
In this case, you use quotation marks to quote him directly.
yes,
And he told you the voices said, "You won't go up to him, you won't, you won't."
yes,
And those were his exact words.
yes, that's what he told me.
He told you he got paranoid,
Yes,
and he told you he saw shadows next to him on the bench.
yes,
Okay, and they grabbed his knife.
yes,
Now, at the time, you did not clarify with Mr. Reales Dominguez whether he was referring to the same bench he was on or or a second bench that was next to him.
I did not.
At that time, that fact didn't seem very important.
No, it did not seem important to me at the time.
But that was one of the facts that Mr. Vanderhook wrote to you about in his cover letter.
Yes.
Because Mr. Vanderhook interpreted your report as Mr. Reales Dominguez claiming he was on the same bench with Mr. Breaux.
Yes.
But Mr. Reales Dominguez never specifically told you that, did he?
No, he did not.
And he told you that he went up to the shadow figure and he blanked out?
Yes.
Then he told you he remembered he saw a face.
Yes.
He told you when he saw this face, he got even more paranoid
Yes.
and scared.
Yes.
And that he then got on his bike and went home.
Yes.
I'd like to talk to you about the second incident. Did you summarize that in your report as well? The one in which Mr. Abou Najm was stabbed?
Yes. I summarize part of it and I put in the record part of it.
Prior to telling you about the incident in which Mr. Abou Najm was stabbed, Mr. Reales Dominguez gave you some background information of things he would do in Sycamore Park.
Yes.
He told you that in 2022, he found a knife when he was going on a walk.
Yes.
He told you he threw it at a tree.
Yes.
And he started doing that, throwing it at a tree.
Yes.
He then told you that you indicated in your report that the knife broke, so in November of his junior year, he bought a knife from Amazon.
Yes.
He told you...
But I also like to point out that I did not ask clarifying question about when the knife broke or how it broke. So details like that I did not think it was important at the time. I did not ask clarifying question.
So you did not ask him whether the knife broke in half or if the blade became dull. It just, he explained to you the knife wasn't working. To some effect.
Yes. Yes.
And that was not an important fact for you, was it?
No, not at the time.
He told you the knife he bought was a cheap knife?
Yes.
And he told you he had started carrying that knife with him since approximately November of 2022.
Yes.
Now I'd like you to assume that he actually bought that knife, ordered that knife, on December 5th of 2022 instead of November of 2022. Is that inconsistency, is that concerning to you at all?
It's not concerning, and as I mentioned earlier, knowing that at the time he was actively psychotic and his thinking or state of mind at the time was disorganized, I do not and I did not expect him to give me timeline minute by minute in a coherent manner, so that did not surprise me.
He told you that he used the knife he purchased to throw at a tree?
Yes.
And he told you he did not purchase the knife to hurt anyone?
Yes.
You then asked him about the second incident in which Mr. Abou Najm was walking, or excuse me, was stabbed?
Yes.
Now in your report you said he saw someone walking with the backpack and pointing and laughing at him.
Yes.
But he also later said he grabbed a bike.
Yes.
So whose bike was it your understanding that he grabbed?
At the time, I was unclear. However, later I actually asked him about that, and I believe he told me that it was not his bike, but I did not include that part in the report.
So he told you that the bike was to the person who he had collided with.
Yes.
He told you that this person was pointing at him.
Pointing, and he said making some gesture at him.
A laughing gesture. Like,
Yes.
And I don't know if you can see me, but like raising the arm up and down. Is that what he does?
Yes. Yeah, he showed me that movement, and he said it was scary to him, and he got more scared and paranoid just because prior to that incident, he saw something similar to that. So in his mind at the time, he felt that again, supernatural being coming after me again.
And he had told you he'd seen a supernatural being using that hand gesture on a prior occasion?
Yes, he did.
Now, in describing this, he used both the term supernatural being and shadows, correct?
Yes, and sometimes he would use shape-shifting shadows, I believe.
And he told you that this supernatural being or shadow collided with him?
Yes,
He told you he fell backward?
yes,
Told you the supernatural being or shadow fell backward too?
yes,
He told you he thought this was a supernatural being coming after him?
yes,
And then the report, he said he grabbed my knife and lunged at him.
yes, because he was scared.
Now, I'd like you to assume a fact. Assume that when Mr. Reales Dominguez testified, he testified he didn't actually remember grabbing his knife. He just remembers lunging. Is that fact concerning to you?
No, it's not.
Why not?
Because of two reasons. The first reason, as I mentioned a few times, about his thinking at the time was incoherent. So based on research, we know that when somebody having disorganized thinking, we cannot expect the person to have thinking or state of mind in a coherent manner. So the memory may not be exactly accurate 100%. So that's my first reason for not concerning. The second reason, it would be because it's not concerning because he did not, overall meaning it did not change in the sense that he experiencing symptoms, he was reacting to the symptoms.
At the time you met with Mr. Reales Dominguez, at that point he knew that he had stabbed a person, correct?
Yes, and that is a great point because I did not ask clarifying question if when he mentioned that, is that from his own memory or was it from the insight about the memory that he had developed later?
Because you know that when speaking to people, they will often fill in gaps in their memory with things they know happened, even if they don't remember it. You've had that happen before, correct?
Yes, all the time. They would try to put things together for them to make sense of what happened.
And he told you that after he lunged at the supernatural being that he was scared.
Yes,
He told you he saw a flashlight.
yes,
He thought it was another supernatural being coming after him.
yes,
So he grabbed the bike and took off.
yes,
He told you he was scared.
yes,
He told you he went across the bridge and left the bike.
yes,
And he then went home.
yes.
I'd like to talk to you about the third stabbing when Miss Guillory was stabbed.
Okay.
He He told you he went out at night to get some fresh air.
Yes.
He went to the train tracks.
Yes.
He sat down for like 10 to 15 minutes.
Yes, that is correct.
Then told you he went on a walk.
Yes.
He told you he saw shadows telling him to come.
Yes.
And so this time he's using the shadows again instead of supernatural being.
Yes.
He was referring to the same thing. That was your understanding, right?
Yes.
And he told you the shadow was calling for him to come.
Yes.
And he was paranoid.
Yes.
He told you the shadow came at him,
Yes.
that it reached out to him.
Yes.
And he told you the shadow was in the tent,
Yes.
and that he stabbed the shadow in the tent.
Yes.
He then told you he heard a scream,
Yes.
that he got paranoid,
Yes.
and that again he thought a supernatural was coming after him,
Yes.
and he got on his bike and went home.
Yes.
Now, Dr. Ree, in your opinion, if a person with schizophrenia is trying to relay their memories of something that happened when they were in florid psychosis, is it reasonable to expect them to have every detail completely consistent, in your opinion?
No, it's not. And I would say even a person without schizophrenia may not have 100% accurate memory either.
And Dr. Ree, based on everything you've reviewed in this case, all the new information you received today, has anything caused you to change your opinion?
No.
I have nothing further. Thank you.
Okay, thank you, Mr. Hutchinson. Any final questions, Mr. Randall?
Yes, Your Honor.
Okay.
Dr. Ree, regarding the cover letter, section 4, that was sent to you, Mr. Hutchinson mentioned that there's a sentence that says that that claim is false. Is there more writing after that?
Yes.
What does it say?
It said, may I read it out?
Okay, go ahead.
It said there is no record of any prior use of the name John Joas or any similar name.
And does it say more after that? Could you finish the paragraph?
All agencies that may have been in the Davis area have examined their records, including the Davis Police Department, UC Davis Police Department, Yolo County Sheriff's Office, California Highway Patrol, and the Department of Fish and Wildlife.
I want to take you back to Mr. Dominguez's statements to you. You mentioned having a prior knife before buying a knife. You remember that discussion?
Yes.
What did he say was the reason why he needed to buy a new knife?
I believe because that knife was broken.
And regarding the stabbing of Karim Abou Najm, in your report, when you're describing Mr. Dominguez's statement to you about what he saw with Karim Abou Najm, does it have the word shadow at all?
May I refer to my notes?
That would refresh your memory.
Okay.
Thank you. Not in that paragraph. However, I would like to add that during the evaluation with him, at one point, I wanted to make sure that he was referring to the same thing. So this one, I remember that I did ask him a specific question if he was referring to the same thing between the shadow and the shadow being supernatural being, and he did confirm with me that in his mind, the shadow was a supernatural being. And that's why he was scared them.
When he was talking about Karim Abu Najm, did he describe what he saw physically? Or did you record a description of what he saw physically?
I believe he said that he saw somebody with a backpack.
Did he describe seeing a shadow with a void in the area of the mouth?
I do not recall that. I do not believe he said that to me.
All right, and then going to the stabbing of Kimberlee Guillory, you just testified about him saying that he went on a walk. Did you talk about one walk or more than one walk?
I do not recall specifically. May I refer to my report?
Is that with the court's permission?
Okay.
Thank you, Your Honor. I believe he just referred to one walk that evening.
I don't have any additional questions.
Okay, thank you.
Dr. Reed, your report, do you have it in electronic form right now, or is it just in a written report?
I just have a written report right here with me.
Do you use the word shadow multiple times throughout that report to describe what Mr. Reales Dominguez told you?
I believe so.
Okay.
I have one more question. Does the fact that Mr. Reales Dominguez used the term shadows at some times and supernatural beings and others, the prosecutor appears to think that's very significant.
Objection, argumentative.
Sustained.
The prosecutor has asked you questions about whether he...
Stop, just ask.
Is the fact that he used shadows sometimes and supernatural beings others, is that significant to you in any way?
No, it is not. Especially he already clarified to me that to him they mean the same.
So as an expert, who, with your expertise, does the fact he used shadows sometimes and supernatural being, is that relevant at all to your opinion?
It's only relevant to the fact that he was having visual hallucinations. They are both visual hallucinations to me.
And he told you they're the same?
Yes.
Nothing further.
Okay, I think we're done. All right, Dr. Reed, thank you for your testimony, and I'm so glad we were able to work it out and that the lawyers agreed to do it by video. And have a great day, okay?
Thank you.
Yep. Thank you. Okay. Just a moment, folks. Go ahead and stand up and stretch. I'm going to conference with the lawyers regarding scheduling. Thank you, officer. Deputy. door didn't close when we went out. Thank you. Thank you. Okay, back on the record, and we're here after taking evidence. So, I think at the beginning of the trial, I told you I would wave a flag, so to speak, each time we entered a new phase of the trial, right? So we have now closed evidence. I'm going to work with the lawyers in just a minute regarding some formal rulings on the documents, the exhibits, and so forth. But evidence is closed, okay? So then that means we are ready to start the legal instruction to the jury and closing arguments. After closing arguments, there will be jury deliberations. Okay. And then I anticipate I would like to start tomorrow. I think I would like to start at 10 o'clock, okay, instead of 9:30 with the jury at 10 o'clock. So, and we may go straight through, right? So normally I take a break, hour 15, hour and a half, bathroom break and so forth, stretch break. But if we start at 10, you may not get a break. So make sure you're ready to sit for up to 2 hours, maybe less than that, okay? All right, do your best. If some emergency happens, you can always flag down the bailiff, or for that you can flag me down too. But that's what I would like to do. So I'm giving you an extra half hour so I can continue to work with lawyers to finalize the legal instructions. Okay, so I expect that closing arguments will take most, if not the full day tomorrow. And it's my hope that I'll give you a final instruction at the end of tomorrow, and that I will send you in to deliberate. I do not know how long your deliberations take, but I'm going to give you more instructions on that when I send you in. I'm going to tell you how to schedule time and how to handle that. I'll also talk to our 4 friends that are alternates. Okay, I'm going to give you, the 4 of you, explicit instructions on what your job is and what your role is and how this works for all of you, okay? And so don't worry about that. Just another thing that's on my mind is the schedule in for next week. I highly doubt that you're going to be able to do too much tomorrow other than gather and meet. And so you'll really start the meat of your, the MEAT of your deliberations on Monday. And so I recall that some of you had asked for June 12th, if my memory serves right, time off on June 12th. And I granted that request for the morning. June 12th is a Thursday. Is that correct? Yeah. So if you get in deliberations, you can talk about that June 12th. Okay, I already committed that you can have that morning off. You may agree to take the whole day off. You may have a verdict before then. That's Thursday. I don't know. You just need to deliberate for a reasonable amount of time. And so anyway, I just wanted to let you know that. I am going to instruct you again and explain that there are 2 phases to this trial. I told you it was a 10-week trial. I still expect this to be 10 weeks of your time. So I'll explain that again. It might make more sense to you now, and so we still have more work to do, okay? And I'll instruct you on that. It may seem vague right now, but I'm going to give you more detail tomorrow. I'm just trying to give you a general reminder of what you signed up for, and how I outlined it early on. So that's where we're at. So today, I think we're done, and I want you back at 10 o'clock tomorrow, and I'll give a lot more clarifying instruction. I realize some of what I gave today was vague, but I just wanted to kind of begin to lay it out there for you. So, good. Remember the 3-part admonition. Don't discuss the case, don't form opinions, and don't research it. And I'll see you tomorrow at 10 o'clock, folks. Thank you. Operator.